moment Congressman said, "I think you just lied under oath," nobody in that room moved. Not the stenographer, not the aides lining the walls, not the members of Congress seated behind the raised committee dais, not the reporters in the gallery who had covered hundreds of hearings exactly like this one and thought they had seen everything a congressional witness table could produce. Nobody moved, because what had just been said into a live microphone in a federal hearing room, on the record, by a sitting member of the United States Congress to the Attorney General of the United States, was not the kind of thing that gets said. It is the kind of thing people think. It is the kind of thing that gets whispered in hallways and typed into legal memos and discussed in the kind of closed-door meetings where everyone agrees something is wrong, but nobody says it out loud. It is the kind of accusation that careers are built around avoiding and destroyed by making. And he said it anyway. 3 words followed by 4. 7 words total. Quiet, direct, delivered without theater or performance, which somehow made them land harder than if he had been shouting. "I think you just lied under oath." The room processed that for exactly 1 second before everything changed. Here is what had happened in the 60 seconds before those 7 words were spoken. The hearing had already been running for hours. Pam Bondi had arrived at that witness table with a strategy. It was visible from the first exchange. Every question about the Epstein files produced a pivot. Every request for documentation produced an attack on the member asking. Every attempt to hold the hearing to its stated purpose. Oversight of the Department of Justice's handling of the most sensitive investigative files in modern American history produced a rehearsed deflection that her staff had clearly spent considerable time preparing. She had a binder. It was full of attack lines, not legal justifications, not documentary evidence, not prepared responses to the specific questions any competent attorney general would have anticipated being asked about why the legally mandated document release had been mishandled. Attack lines, personal jabs, political opposition research compiled by the staff of the nation's top law enforcement officer for the purpose of embarrassing the members of Congress who were trying to do their jobs. That binder is important context, because when you understand what Bondi brought to that room, what she chose to prepare instead of answers, the exchange that followed stops being a surprise and starts being an inevitability. The congressman had a document, not a summary, not a secondhand account, a physical document. A witness statement from an individual who had contacted the FBI's National Threat Operations Center. This was not someone who had been sought out by investigators. This was someone who had come forward voluntarily, who had picked up a phone and called the federal government and said, "I have information. I was there. I heard things. I need to tell someone what I know." The statement described specific events. A limousine. A phone call overheard between 2 men whose names the federal government knew well. A young woman this witness had encountered who described what had been done to her. Details that, if accurate, placed the connection between the President of the United States and Jeffrey Epstein in a different category than a social acquaintance or a passing familiarity documented in party photographs. The Department of Justice had never interviewed this witness, not once. Not a phone call, not a letter, not a formal request for a follow-up meeting. Someone had called the FBI's Threat Operations Center and left a statement connecting the most powerful person in the country to the most politically sensitive investigation in the country, and the Department of Justice under Pam Bondi had looked at that statement and done nothing. The congressman laid this out methodically. The witness, the statement, the content, the date it was received, the complete documented absence of any follow-up from the department that was supposed to be pursuing justice for over 1,000 survivors of Epstein's trafficking network. Then he asked the question. He asked Pam Bondi whether there was evidence connecting the president to Jeffrey Epstein's operation. And Bondi said, "There is no evidence that Donald Trump has committed a crime. Everyone knows that. This has been the most transparent presidency." The room shifted, not dramatically, not with gasps or raised voices. The shift was quieter than that and more consequential for being quiet. It was the shift of people who had been watching a hearing proceed along predictable lines, suddenly registering that the lines had just been broken. The reporters in the gallery leaned forward. The aides along the wall stopped their quiet side conversations. The members of the committee who had been half reviewing documents while their colleagues spoke put the documents down, because that answer had a specific problem. The congressman was holding the problem in his hands. A witness statement in the FBI's own records. A document produced by the federal government's own threat reporting system. Filed, time-stamped, preserved. Evidence. The word she had just used. The thing she had just said did not exist. He looked at the document. He looked at her. And he said it. "I think you just lied under oath." What happened next revealed more about the state of the Department of Justice than anything that had been said in that hearing up to that point. Bondi did not say, "That is factually incorrect, and here is why." She did not say, The document you are referencing does not meet the legal threshold for evidence under the applicable statute. She did not say. I was not aware of that specific filing, and I will direct my department to review it immediately. She did not produce a counter document. She did not call a witness. She did not offer a single piece of information that contradicted the document in his hands or explained why it did not constitute what he said it constituted. She said, "Don't you ever accuse me of a crime." 7 words answered by 7 words. His were legal observation grounded in a physical document. Hers were a warning, a boundary, a declaration that the accusation itself, not its accuracy, not its legal foundation, not its evidentiary basis, was the thing that required a response. Don't you ever? In a courtroom, that answer would be marked non-responsive. At congressional hearing, it meant something different. It meant that the Attorney General of the United States had been presented with apparent evidence that she had made a false statement under oath, and her response was not to address the evidence. Her response was to make clear that the person presenting it should not have done so. That is not the response of someone who has been falsely accused. A false accusation is easy to defeat. You produce the counter evidence. You correct the record. You welcome the scrutiny because the scrutiny will vindicate you. The response of someone who has been falsely accused is, "Let me show you exactly why you are wrong." That is not what happened. What happened was a warning, and warnings in hearing rooms, under oath, on camera, tell a story that the words surrounding them cannot. The silence that followed lasted longer than silences in congressional hearing rooms usually last. There is a rhythm to these proceedings. Question, answer, follow-up, objection, recess for votes, return, repeat. The rhythm exists because it creates the illusion of process, of accountability functioning as it is supposed to function, of the right questions being asked and the right answers being demanded, and the institutional machinery producing something that resembles justice, even when it produces nothing of the kind. The silence broke that rhythm. It sat in the room like a third participant in the exchange, heavier than either of the 7-word statements that had created it. And it lasted long enough that everyone present understood they were inside a moment that would be referenced in future discussions of this hearing for as long as this hearing was discussed at all. Then the chairman called for order, and the hearing continued, and Bondi reached for the binder, and the rhythm resumed. But the 7 words were already in the record, both sets of them. Let's go back to the document, because the document is the thing the warning was designed to make people stop looking at. The FBI's National Threat Operations Center exists for a specific purpose. It is the mechanism by which ordinary citizens can report threats and information to the federal government. When someone calls that line and leaves a statement, that statement enters the official record. It gets filed. It gets preserved. It becomes, by definition, a federal document. And when a federal investigation is underway that touches on the subject matter of that statement, the existence of that statement in the federal record creates an obligation. Investigators are supposed to know it is there. They are supposed to evaluate it. They are supposed to make a documented decision about whether to follow up. The decision not to follow up is itself a documented decision. There should be a record of someone at the Department of Justice reviewing that witness statement and concluding, for articulable reasons, that it did not warrant an interview. That record should exist. And if it exists, it can be produced. And if it can be produced, it can answer the question the congressman was asking. He asked for it. She warned him not to accuse her of crimes. The hearing had arrived at a moment that congressional oversight processes are theoretically designed to prevent, but rarely manage to address in real time. A cabinet officer under oath had made a statement that a sitting member of Congress, holding a document from the federal government's own record system, had characterized as a lie. And the cabinet officer's response had been to threaten rather than refute. This is the anatomy of what accountability failure looks like when it happens in public. It does not look like a dramatic villain monologue. It does not look like a smoking gun revelation that sends the room into chaos. It looks like 7 quiet words met by 7 quieter ones. It looks like a document held in someone's hands going unanswered. It looks like a warning delivered so calmly it takes a moment to register that a warning is what it was. I think you just lied under oath. Don't you ever accuse me of a crime. That exchange is now part of the permanent congressional record. It cannot be sealed. It cannot be redacted. It cannot be reclassified or marked as duplicative or filed in a vault where no one will see it until a subpoena forces it into the light. It happened on camera, in a federal hearing room, in front of the American public, and the document that prompted it, the witness statement that the Department of Justice received and never followed up on is also part of that record. What the hearing established in that 60-second exchange was not guilt. Courts establish guilt. Juries establish guilt. The standard of evidence required for criminal conviction is a different standard than the one that applies in a congressional hearing room. What the hearing established was something else. It established a gap. The Department of Justice had received a witness statement containing information potentially relevant to the most politically sensitive investigation the department was handling. The Attorney General said there was no evidence. A member of Congress said he was holding evidence. The Attorney General's response to that contradiction was to warn him not to say it again. The gap between those two positions, between no evidence and here is evidence, is not a political disagreement. It is not a matter of interpretation or analytical framework or differing legal philosophies. It is a factual question with a documentable answer. Either the statement exists in federal records or it does not. Either the department reviewed it and decided not to follow up with documentation of that decision, or it did not. Either the witness is reachable and willing to be interviewed. The congressman said explicitly that they were, or they are not. These are answerable questions, every single one of them. The answers exist somewhere in the files of the Department of Justice, and the Attorney General of the United States was sitting in a room where she could have provided them. She warned him instead. There is a reason that moment. Those 7 words, that warning, the silence that followed, is the moment people will remember from that hearing. Not the procedural arguments, not the prepared statements, not the legal back and forth about evidentiary standards and investigative thresholds. Those things matter, but they don't land. They don't register in the gut the way that exchange did. What registered was the simplicity of it, a document, a question, a statement the document appeared to contradict. And the response of the person whose job is to pursue truth was not to pursue it, was not to correct it, was not to explain it, was to warn the person who found it. That is the story of what happened in that hearing room. Not the binders of attack lines, not the legal arguments about redaction standards, not the procedural disputes about document production timelines. The story is a congressman with a piece of paper and a question and 7 words answered by 7 other words that told the room everything it needed to know. The witness statement is still in federal records. The interview still has not happened. The gap between no evidence and here is evidence is still open. And the warning that was issued when someone pointed at that gap is also still in the record. Sitting next to the gap it was supposed to close. It didn't close anything. It just made the gap more visible. And somewhere in that hearing room, after the warning landed and the silence broke and the hearing moved on to the next question and the next deflection and the next page of the binder, the document was still in his hands. He had not put it down. And that detail, the physical persistence of holding a document that has just been denied, is the detail that captures everything about what the Department of Justice had become under Pam Bondi's leadership, because the document did not disappear when she warned him. The witness statement did not vanish from federal records because she said there was no evidence. The gap did not close because she chose not to address it. Reality does not cooperate with warnings the way subordinates do. Let's go further back. Because the exchange over that witness statement did not emerge from nowhere. It emerged from a context that had been building for months before that hearing room ever convened. The investigation into Jeffrey Epstein's network did not end with his death in a federal jail cell. The documentation did not stop accumulating when the primary subject of the investigation was no longer alive to be prosecuted. Federal investigators had spent years, building a record, interviewing witnesses, subpoenaing financial records, mapping the network of individuals who had used what Epstein ran. That record existed. It sat in government files, classified and controlled and managed by the very department whose leader was now sitting at the witness table saying there was no evidence. The contradiction between those two facts, an extensive federal investigative record on one side and a sworn statement that there was no evidence on the other, is not subtle. It does not require legal expertise to identify. It requires only the willingness to hold both facts in your mind at the same time and ask what the distance between them represents. That distance has a name. The hearing room was trying to name it. The document in the congressman's hands was part of naming it. And the warning not to say it again was the sound of someone trying to prevent the naming from completing. There is a specific quality to the kind of silence that falls after someone says something that everyone in the room knows is true, but that no one expected to be said. It is different from the silence of shock or the silence of confusion. It is the silence of recognition, of people looking at each other and understanding that whatever pretense had been maintaining the surface of the proceeding had just been stripped away. The congressman had not shouted. He had not performed. He He had said 7 words in the same tone someone uses to read a weather report, and the room had gone still because the stillness was the only honest response to what had just been said and what it implied. The witness statement itself deserves more attention than the warning it produced. An individual had called the FBI's Threat Operations Center. That person had been in a position to observe. They had heard a phone conversation between the President of the United States and Jeffrey Epstein. They had encountered a young woman who described being assaulted. They had been disturbed enough by what they witnessed to contact the federal government and put their account on record. That is not a trivial act. Contacting the FBI with information about the most powerful person in the country is not something someone does lightly. The decision to make that call, to leave that statement, to create a formal record of what they had seen and heard, that decision carries weight. It carries risk. And it produced exactly one outcome. Silence from the Department of Justice, no interview, no follow-up, no documented decision about whether the information warranted investigation. Just the statement in the file and the absence of any response to it. And then, when a member of Congress found that statement and held it up in a federal hearing room and asked the Attorney General why no one had spoken to this witness, the Attorney General said there was no evidence. The statement is evidence, by definition, by the plain meaning of the word. A first-hand account from an individual who was present, who observed, who contacted the appropriate federal authority, and who the congressman confirmed was still willing to speak. That is evidence. It may not be sufficient evidence to prosecute. It may not meet every threshold required to open a formal investigation. Those are legitimate legal distinctions that a competent attorney general could explain clearly and on the record. But that is not what was said. What was said was that there was no evidence. And there was a document in the congressman's hands that was evidence. And the response to that contradiction was a warning. The room understood what it was watching, even if no one said it plainly in the moment. Congressional hearings operate on a specific frequency. There is the official record. The questions asked, the answers given, the statements entered into evidence, the procedural motions and legal objections and parliamentary maneuvers that make up the formal structure of the proceeding. And then there is the actual communication happening underneath all of that. The pauses, the deflections, the choice of which question to answer and which to redirect, the warnings issued in response to accusations rather than evidence offered in refutation. The actual communication in that 60-second exchange was not about a witness statement. It was about something larger. It was about who was allowed to say what in that room, about which accusations could be spoken aloud and which were supposed to remain in the category of things people think but do not say, about the distance between what the congressional record showed and what the Attorney General was willing to acknowledge that it showed. I think you just lied under oath. 7 words that collapsed that distance into a single sentence. That refused to maintain the fiction that the contradiction between the document and the sworn statement was a matter of interpretation or legal nuance or differing analytical frameworks. That said, plainly and directly and on the record, what the evidence in the congressman's hands appeared to show. Don't you ever accuse me of a crime. 7 words that tried to restore the distance. That attempted to make the accusation itself, rather than its accuracy, the subject of the room's attention. That issued a warning to the institution of Congress that certain conclusions, however well evidenced, were not to be stated in the presence of the person they concerned. It didn't work. The room had heard both sets of words. The camera had captured both sets of words. The stenographer had recorded both sets of words. The permanent congressional record now contains both sets of words, sitting next to each other, available to anyone who wants to understand what happened in that room and what it meant. What it meant is not complicated. It meant that the Attorney General of the United States, under oath, in a federal hearing room, had made a statement about the existence of evidence that a sitting member of Congress, holding a federal document, characterized as false. And the Attorney General's response to that characterization was to warn the congressman rather than to address the document. That sequence, statement, contradiction, warning, is the story of what accountability looks like when the institution responsible for accountability has decided that accountability is the thing it is protecting against, not pursuing, protecting against. Consider what it would have cost her to answer differently. To look at the document in the congressman's hands and say, "You are right, that witness statement is in our records. I will personally ensure an interview is conducted before the end of the month." That answer would have taken 15 seconds to deliver. It would have been the legally correct response. It would have been the institutionally appropriate response. It would have been the response of an attorney general who understood that the purpose of a congressional oversight hearing is not to perform loyalty to the administration that appointed her, but to account for the conduct of the department she leads. It would have cost her nothing except the acknowledgement that something had been missed, that a witness who came forward had been ignored, that the gap between the official position and the documented reality existed and deserved to be addressed. She could not say it. The warning was the proof that she could not say it, because the warning came in the place where an answer should have been, and warnings only replace answers when the answer is the one thing in the room that cannot be spoken. The document is still in federal records. The witness is still willing to speak. The interview still has not happened, and the warning that was issued when someone noticed all of that is also still in the record, sitting next to the gap it was supposed to close, still open, still visible, still waiting for someone to answer the question that was asked in that room and never received an answer. There is one more thing that needs to be said about what happened in that hearing room after the 7 words landed and the warning was issued and the rhythm of the proceeding resumed. The hearing continued for some time after that exchange. Other questions were asked. Other deflections were produced. The binder was consulted. The attack lines were deployed. The procedural machinery of congressional oversight ground forward in its slow and imperfect way. And through all of it, the congressman held the document. He did not put it on the table. He did not pass it to a colleague. He did not set it down when the next question was asked or the next answer was deflected. He held it. And every time the hearing moved to a new topic and the room's attention shifted and the cameras adjusted and the transcript moved forward, the document was still there, in his hands. A physical object in a proceeding that was trying to make it abstract. A piece of paper that refused to become a rhetorical point or a legal argument or a line in a transcript. That existed as itself, as evidence, as a thing that had been in the FBI's records, unactioned, while over 1,000 survivors waited for a department that had apparently decided the most transparent presidency in history could not be disturbed by a limousine driver's statement. The hearing ended. People filed out. The stenographer closed the record. The cameras stopped running. The document went wherever documents go when the hearing is done and the room empties and the institutional machinery that produces these proceedings moves on to the next one. But the record remains. The exchange remains. 7 words and 7 words, and the silence between them and after them and around them, preserved in the permanent congressional record, available to anyone who wants to understand what accountability looks like when the institution responsible for it has decided to protect itself from it instead. Just a warning, just 7 words, and a document that never left his hands.